My name is Levi Jonathan. I've gotten two notices in the past 2 weeks, at least week and a half, I would say, that acknowledge of a new case, and then I received this notice that denies the case on the basis that I was filing for a belated appeal. My intentions wasn't to file for a belated appeal. It does say here that, well, my interpretation is it says belated appeal to seek post-conviction. I don't know. Does that give me an
Well,
option?
what happened apparently, whatever you filed was initiated by this office as a petition for belated appeal, rightly or wrongly.
Okay.
And so that's why it describes that as the proceeding. And it's denied in the panel. My best interpretation of this had nothing to do with the outcome of this. My best interpretation is what you were seeking was really not a belated appeal, but relief that may be available through this criminal rule, which is a collateral attack on a conviction. That's the best interpretation I can give that.
Collateral attack?
Well, that's what a Rule 3850 is, a collateral attack on a criminal conviction, which is filed with the circuit court, not with this court. You file with the circuit court. If it's a criminal conviction from circuit court, you file it there. If that's unsuccessful, you would have a right to appeal here.
Yeah, well, that's what I initially did. I filed with the circuit. I got the letter from the judge stating to come here and file, and I did that.
Okay, well, when you come here, that's not an appeal. An appeal is initiated by filing the notice with the circuit court clerk, not with this court. If you want me to take a look at this, I will, and I may be able to give you more intelligence if you give me a few minutes.
Sure.
Okay.
Yeah. Well, this was the instructions I was given. Critical time requirements for appeals from final orders. It says 70 days from notice of appeal. For serving initial appeals, brief and civil appeals, 80 days, and criminal appeals, 15 days. Summary appeals option, 10 days. Voluntary response to opponent's motion. Of course, this is lawyer jargon. You'd think if they had a system of laws, and that was the most important thing in their civilization, then they would do a better job of explaining to people instead of using language that's very difficult to interpret. And I can only assume that that's done for a reason, so that people don't actually know how the law operates, so that the maximum amount of revenue can be extracted from people. As long as you can convince people that they have done something wrong, whether they have or not, they're usually willing to pay a price. And I think that that's what the lawyers have become experts at, is basically hitting their big stick on the ground. You know, you did something wrong and you have to pay, it's just the way it goes. But it doesn't always go down like that. And that's why we're here. We are here for every single person who has been wrongly convicted, so that we can try to assist them in their process. I don't believe it's going to come through for me. That's okay. I've got other plans. But for other people that might be interested in, fighting a conviction, I hope this video can serve for some purpose. And, a lot of people want to drink or watch pornography or go to the club or watch a movie. I'm not into that stuff. I'm into protests. I'm into human rights activism. Yes, sir.
Okay. Here's what we got originally from you.
Sure.
Okay, and then the question was posed, should this be treated as a petition for belated appeal, to which I said yes. Because what this thing seems to say is that you were seeking review of something for which more than 30 days had run, and therefore your time had expired. Mm-hmm. And then the order from the judge that you also gave us said that if he wishes to appeal his sentence, he must file a petition for belated appeal with the Second District, which is what we treated this as. Mm-hmm. The panel did not seem to treat it like that. I would have handled things a little differently. But what they went ahead is, and they just denied it and said that you could file a Rule 3850 motion, which I don't think is dispositive. If you're trying to get an appeal from something from 2014, is that what you're trying to do? 2013. You could either file a motion for rehearing on this.
Well, by the way,
well, let me finish my sentence
yes,
first.
sir.
You could either file a motion for rehearing and say, you've misunderstood. I want to get an appeal from this 2014 case. I don't want to file Rule 3. And can you reopen this and allow me to file a fuller petition? That's one alternative. The other is you could just let that go. You could file an additional new petition for belated appeal. I would improve upon the product you had here. I would look at the rule and find out what the requirements of the rule are, spell out all those things in the petition, and then file another one and do it that way.
I understand what you're saying. Let me ask you, do you have a specific document that I can fill out for a petition, a belated
No, we don't have a
appeal?
form for it, but I can tell you what the rule number is, and you can just look at the rule, and the rule will tell you.
305? Is that the one you keep telling me, 305?
No, it's an appellate rule. I'll write it down for you right here if
Okay,
you want.
yes, sir. You can write it on this, because this is the instruction.
So the appellate rule 9141C, you can access that from our website, the appellate rules, from the legal resources. It's the appellate rules, I'll begin with 9. It's 9.141C.
Right.
That describes petitions for belated appeal. And if you want to go ahead and either try to file a motion for a hearing on this one, which I don't know if that's the best thing, you might want to just let this one go and start fresh. Acquaint yourself with the rule, file a new petition for belated appeal. That would be the way I would go.
I understand.
Okay?
All right. Is that mine?
These aren't, but you can have them.
Sure. Why not? Okay,
Our
thank
business
you
is
very
done?
much.
Okay.
Yes, sir. What was your name?
Jim Burkholder.
Jim?
Yeah.
Thank you, Jim.
Okay.